Hello from the Authors Guild. Welcome to Copyright Basics with experts from RightsClick. We talk a lot about copyright at the Authors Guild, but we're happy to have special guests here today to bring their perspective on what authors and aspiring authors and other creators should know about copyright, protecting copyright, the effects of artificial intelligence on copyright, and more. I'll say as a general disclaimer, this webinar is offered for informational purposes and should not be construed as legal advice and so forth. If you're an Authors Guild member, a professional level member, feel free to use our legal services. Reach out for advice from our legal staff anytime. And now our guests here from RightsClick, they'll tell us more about what they do. But David Newhoff has more than 10 years experience as an advocate of creators' rights. He has a background in film production and communications. Since 2011, he's written over 900 articles. And in 2020, he published the book Who Invented Oscar Wilde, the photograph at the center of modern American copyright. Stephen Tepp has more than 25 years of experience with an extensive background in IP law and policy, beginning as an attorney for the US Senate Judiciary Committee, after which at the US Copyright Office, and then at the Global Intellectual Property Center of the US Chamber of Commerce. Before co-founding RightsClick, he started the IP consultancy Sentinel Worldwide, and he teaches copyright law at George Washington University Law School. David, Stephen, thank you so much for being here, and I'll turn it over to you now. We'll have some Q&A in a bit. Thank you.
Terrific. Thank you. Thank you very much for everyone attending. Thank you, Johnny, for that introduction. In fact, you've obviated the need to go through our first slide. So I won't repeat everything Johnny just said about background, except to say that speaking for myself, I come from a creator background, not from a legal background. As Johnny said, I've been involved in copyright advocacy for about 11 years now. I write the blog, The Illusion of More, which is followed by creators and policymakers, etc. And along the way, I've naturally acquired a lot of information and knowledge about copyright. And so that in terms of why we're here today as RightsClick, and I'll let Steve, of course, introduce himself, is that this is very much a collaboration to create a business that serves creators and helps independent creators make the best use of the copyright system by becoming copyright literate, and also by providing tools and resources to help with that. And so with that preamble, I'll turn it over to Steve for what he can add, and we'll talk about copyright basics.
Great. Thanks, David. Thanks, Johnny. Thanks to the Authors Guild. It is a pleasure to be with you today. Again, Johnny's told you my background. I won't repeat it. RightsClick was founded because David and I have seen from our respective careers and perspectives how the US copyright system is leaving creators behind, particularly independent creators. And we knew that we could build a tool that would make the copyright system accessible to all creators. And that's what we're about. We're happy to answer all the questions, as many questions as we can today. RightsClick is designed, as David said, to make it easy for you. And I'll just note that for those of you who are aware of Mary Rasenberger's background, she was also at the Copyright Office. She and I worked together at that time, so it's a pleasure to continue working with her and her team in our new capacities. And likewise, Kevin was at the Copyright Office. I had left by then, so I didn't have the pleasure of working directly with him, but I've known and worked with Kevin for many, many years. And I'll just say the Authors Guild is well represented. So we begin with some basics about what copyright is, how it's protected, and why registration is so important. The first question that often comes up is when people say, well, I want to copyright my work. Technically, every copyrighted work is protected at the instant it is created, that is fixed in a tangible medium of expression, automatically by operation of law. Registration will secure to you important rights and remedies that I'll discuss in just a moment. And that's more than a semantic difference. It becomes material in some cases, but just for terminology purposes, copyright happens the moment the work is created. Registration is what you need to do to protect your rights. How long does copyright last? The life of the author plus another 70 years. Good long time. That said, there are also a lot of exceptions. We'll get to those later. Copyright is essentially a bundle of rights, specific sorts of things that the copyright owner has the right to either authorize or prohibit. The right of reproduction, the right to make copies, the copyright. The right of distribution, to distribute copies. The right of public performance or public display of the work. And the right to adapt the work. So I'll bet you've all heard, oh, they sold the movie rights for X amount of dollars. Well, you can look at the Copyright Act until the end of time, and you will never find the term movie rights. What that is it's an adaptation or a derivative work that the author of the book is authorizing for a movie studio to produce. Okay, happy to answer more questions about the particulars of copyright as we go, but I wanted to make sure we started everyone with a base level of knowledge. Now we turn to registration. Why is registration so important if copyright is automatic? Well, the copyright law says protection attaches automatically, but the law withholds certain remedies if you haven't registered. The first is you can't go to court as an American author. You cannot file a copyright infringement lawsuit unless you have first registered your work. Obviously, that's critical. And even if you don't imagine, oh, I'm never going to go to court, that's so expensive. Even if you're in a negotiation over an unauthorized use of your work, and neither side really wants to go to court, if you have registered the work, you have the power of that registration behind you, and it strengthens your negotiating position with someone who made an unauthorized use. So no matter where you are in the spectrum of what you're interested in doing, registration always puts you in a stronger position. A registration certificate issued by the Copyright Office is what's known as prima facie evidence of the facts stated in the certificate. That is, the court will assume that everything on the document is correct and accurate, and it's up to the defendant to prove otherwise. So proving that the work is copyrightable, the Copyright Office doesn't issue a registration unless they think the work is copyrightable. Proving that you are the author. If you're listed as the author on the registration, then the court will assume that unless the defendant proves otherwise, and so on. The other quick couple of things, statutory damages and attorney's fees, those are critical remedies. Statutory damages means instead of having to prove the exact harm that you suffered because of an unauthorized use, you say to the court, just pick from the statutory damages range in the law. That is currently between $750 and $30,000 per infringed work for an ordinary infringement. If the infringement is willful, it can go up to $150,000 per infringed work. So if you've got multiple works infringed, that can multiply pretty darn fast. If you haven't registered before the infringement started, or within 3 months of first publication of the work, then you can't opt for statutory damages. You have to prove your actual damages. With attorney's fees, again, if you prevail in the infringement action, you can ask the court, and in addition to the damages, I want the defendant to pay my legal fees. And that's not an automatic, but you can't even ask for it if you haven't registered before the infringement started. And so our advice to every creator is register before you share your work with anyone. That way, you know that you have maximized your protection and your remedies in all circumstances.
Thanks, Steve. And just to double down on that statement about prima facie evidence, no, do not put your work in an envelope and mail it to yourself. I mean, you can if you want to, but that is proof of nothing. We say it all the time. People ask it all the time. The poor man's copyright is a myth. Don't waste a stamp. So building on basics about registrations, what are some specific questions that come up a lot with regard to publishing and writing? One is, who's going to do it? There are no absolute hard and fast rule here. I can talk from my own experience with my book, for example. And this is fairly common, that if you have a publishing deal or intent or believe you're going to get a publishing deal, it is often the case that in the contract, the publisher is going to take care of registering the work. That's also helpful because if they're going to do it immediately after publication, they're also going to be responsible for sending in 2 copies of the work, usually hardbound copies, and you want that to be their responsibility. And they will usually file the registration on your behalf. However, it's good to be involved in that process. It is not uncommon that publishers get busy and forget and don't get it done on time. The smaller the publisher, the more likely that is to occur. It's also a good idea to check in your contract who's going to be responsible for filing that registration and keeping on top of it. I know I wrote a book about copyright. I was going through a small university press, and I was kind of a pain in the neck. Who's getting this done? When is it getting done? They probably never had an author ask that question that many times. It should be done within 3 months of publication. So if it's not registered prior to that, the work should be done prior to the 3-month date after publication. Which version of the work comes up a lot. So what you might do, sometimes people will write a manuscript, they'll register it themselves, and then send it off to the Copyright Office, and then they say, oh wait, I revised this. Do I need a new registration? Good question. There's no hard and fast rule there. It might be a really good moment to ask the legal counsel that you have at Authors Guild or some other attorney, because it's a bit of a judgment call. Keep in mind that whatever you sent the original time, that's fully protected. The question is, what do you send? How much revision did you do? What kind of revisions did you do? Because really what you're doing is sending a registration for a derivative of the original, protecting the new work. And so that's why I say it's kind of a judgment call in the sense that, if you just kind of change the grammar here and there, that might not be a reason to re-register. But again, if you're uncertain, that's really a good question for legal counsel, but it's one that comes up all the time. That's why I have derivative works on the slide. It's to keep in mind that what you're sending is a derivative, and you'd be telling the Copyright Office, yes, there's a prior registration on this work. Here's the registration number, and then here's the derivative of that if necessary. The class of work that any writer is likely to produce is generally, we're talking about literary work, so novels and poetry and short stories, etc. However, if anybody here is writing a screenplay or a stage play, those are not literary works. Those are called works of the performing arts. So you're actually submitting under a different category. Don't get me started on the various names that the Copyright Office uses in its categories. Some of them are not intuitive, to say the least. But anyway, that the principle there is, of course, those are works meant to be performed, and so they are considered works of the performing arts. The basic process of registration is that you have to, you have to fill out the application, which consists of course, who's the author, who's the claimant. It's often the same person. And you must pay a Copyright Office fee that is non-refundable. And you must submit a deposit copy. So if it's you doing it yourself, as opposed to say the publisher sending in physical copies, you would upload, for example, a Word document or a PDF, etc. There's a list of different file types that are acceptable I don't think there's anything in the normal world of text documents that are not acceptable. And then, of course, a common question we get a lot of times is, how long does the Copyright Office take? How long is a piece of string? It really depends. The Copyright Office can take up to several months to process a registration. But candidly, even with some works that are, say, a single screenplay, I've seen them do it in 2 weeks. So it really depends. Just so you know, within the Copyright Office, their process is they're going to check the application for correct information, and basic administrative procedures have been followed. They're going to look at the deposit copy and make sure that it is what it claims to be, that you haven't accidentally clicked the wrong PDF and sent them your tax form instead of your manuscript or something like that. That would be the kind of situation where the Copyright Office would then contact you and say, hey, there's an error here. Going back to what Steve said about registering early, this is a big question that comes up a lot, which is when does the protection kick in? So imagine you sent in a registration tomorrow, and next week somebody infringes your work. The court would require that you receive that certificate before you can actually proceed with a case. However, the effective date of your protection was the day the Copyright Office received that application. So that's why getting the timely registration in is so essential. The only exception to that would be if for some reason the Copyright Office rejected an application because it lacked originality, which gets into we can talk about that further. That would not be very common in this world. We see it sometimes in say graphic design, where there's sometimes question as to whether or not there's enough creativity in that. Pretty much if you sent in a story, the Copyright Office is unlikely to say, well, this lacks originality. However, that's the only exception there. And we can go into more detail if people have questions. With all that said, we wanted to demo a little bit about what we built in RightsClick and why. So I'm going to go to this vis-a-vis registration. Oh, we don't want that. We want this. So there's a couple of processes, a couple of ways we looked at registration. One was just for simple one work. If let's say you write one work every once in a while, we added a single work registration feature on our website fairly recently. This is our copyright registration page. It has actually a lot of information about registration here that answer a lot of common questions. But we also have a one work registration tool. You can, of course, go to the Copyright Office. The Copyright Office is accessible to anybody. Anybody can use it. However, a lot of people find it clunky and confusing. It is software from the 1980s, so it is not necessarily the most intuitive thing in the world, and we find that that's a barrier in and of itself to a lot of people registering. So that's one reason we set out to try to make it simpler. So this is really just a very, very simple form. You would simply tell it what kind of work you're sending in. And this process through us is limited in that it must be one work. It must be one of the types that we list. It must be something that you and you alone created. So there's no joint authorship that gets, sorry, those are the main restrictions. And through this, we process one, we charge a processing fee ourselves of $29.95 on top of the Copyright Office fee, which if you look around at one work registration options that are out there on the internet, it's cheaper than all of the above. For example, LegalZoom, I think, charges $114 or something per registration, which is, we think, a little high. Alternatively, we also built RightsClick, the tool. RightsClick is a software suite. As you see, it has a number of functions. I'm not going to go through all of them here. We're here to talk broadly about copyright. However, the distinction might be, let's say you produce a bunch of short stories on a regular basis, and you've written these on spec. Some you might send to contests, some you might send to magazines. You're not sure what you're going to do. You're not necessarily going to compile them all into one anthology, let's say. RightsClick is designed to build a portfolio of works. So as you see here, I've loaded 12 works into a project that I've just called 2024 Stories. And all I did was tell it the type of work I'm working on and upload these files, which I won't make you watch me do. You'll recognize these common titles here. And for example, all you would have to do in RightsClick is update the information. You could actually group update information here. I'm just doing this very quickly. Let's say I produced it last month. And that's about 50% of the way through the registration process with us. And what we would do, you would answer a couple more screens and then submit it through RightsClick. And then what this does is, in this case, you're taking advantage of what's called group registration. So in the case of 12 unpublished works that would go on 2 applications, because the Copyright Office allows you to do up to 10 unpublished works in a group on 1 application. We don't make you bother with all that. We basically, if you put 14 in here, it would still be 2 applications, etc. We take care of that piece of it. And then what happens is in each title, you see this stuff updated. So for example, once it's submitted to the Copyright Office, this updates with the application date. That's that effective date of registration. The case number is entered. And then once the Copyright Office issues a certificate, this switches to yes, and that registration number appears. And then that gets assigned to all the titles within the project, so that, as we say, you're building a portfolio of works organized according to copyright relevant information, which you can then have at your fingertips. So this applies very much to people who are producing larger volumes of work, perhaps large volumes of short works, poetry, etc. Again, happy to answer more questions, but we want to be respectful of your time. There are also infringement assessment, or rather enforcement tools, and etc. in here, and an opportunity to find attorneys through RightsClick. We don't recommend them per se. We're just giving you a list of access. And then, of course, we also support this, not by offering legal advice, but administrative advice, etc. And we answer questions very rapidly. I'll go back to the slideshow here real quick to come back to. We wanted to answer, I'll turn it back to Steve. We wanted to try to address a lot of other common questions that we see, and then we'll turn it over to you all for Q&A.
Thanks, David. So it's good that we got to this, because I saw a number of questions coming in. I'm trying to answer as many as I can, but there's too many of you. We'll do as best we can. So some basic limitations on what copyright does not protect. Facts and ideas. Copyright protects your particular expression. It does not protect the underlying fact. So to say that today in the Washington, D.C. area, it's 85 degrees, that is a fact. As opposed to a creative expression of a humid, sticky day in Washington, spring day in Washington, and so on. That expression could be protected, but the fact of 85 degrees is not. Likewise, ideas are not protected. The idea of, a wise old wizard who guides a young budding sorcerer or something like that, whether it's Yoda or Gandalf or Professor Dumbledore, those individual expressions and those particular characters are copyrightable, but the generic idea of a wise old wizard is not copyrightable. Short phrases, titles, individual words, per se, not copyrightable, automatically not copyrightable. So someone asked about registering the title of a work, registering the author of a work. You need to register the work, the book, the poem, so on. And those are some limitations on what copyright applies to. There's also a set of exceptions in the copyright law. The most well-known and the broadest is called fair use. And this cuts both ways for literary authors, because on the one hand, it may mean that someone can take a passage from one of your works and use it, and it may not be infringement. On the other hand, it may mean that you can do something with someone else's work, a quotation, for example, that you want to comment upon. Fair use is a very flexible doctrine, but it's also very hard to nail down to say a bright line, yes or no, yes, this is, or no, this is not. One of the great things that we built into RightsClick that is unique, no one else has this, is an infringement assessment tool, which will ask you just a few questions about a particular use that you either have found someone made of your work, or that you could put in a use you'd like to make of someone else's work. And while RightsClick is just a software program, it can't give you legal advice. It will help focus you in on what are the key issues and give you guidance as to what the law favors or disfavors in terms of fair use, from which you can decide whether or not, if someone else used your work, whether you want to pursue some sort of initiative against them, or if you're considering using some aspect of someone else's work, that can help you decide whether you need to go and ask for permission for that, or ask a lawyer for further guidance, that sort of thing. No one else has that sort of a tool, and it can save you, we think, quite a bit of time and money. If you're subscribed to the Authors Guild at the level where you get legal counsel from them, you could take that assessment and email it as a PDF to the right person at the Authors Guild, and it would save a lot of time because it would distill for them exactly what you have in mind, and they could give you legal advice from there.
So to finish off,
David, you're breaking up.
Q&A. I'm sorry, am I back?
You're back now. You were
okay,
very
good.
choppy for a moment.
Sorry, it might have been while the slide was changing. Some questions that come up a lot, and certainly that I faced as well, working or continue to, that are both copyright and kind of pragmatic. One thing to dispel with right away, see it all the time, it's kind of like the B side of the poor man's copyright question is, does attribution make any difference? It certainly does not in terms of copyright infringement. It's good to attribute, and sometimes it's necessary and required that you attribute, but it does not excuse an infringement, and so it should never be mistaken as whether or not you've infringed somebody's copyright. And then in terms of, I see a lot of questions come up all the time about obtaining permission, obtaining licenses for different types of work. And so, one thing to consider is whether or not are you looking to obtain a license, or are you interested in using factual material versus expressive material? As Steve mentioned, copyright does not protect facts. So are you really, are you quoting somebody, or are you simply taking something you learned from, say, a book that is factual, it's part of the record, it doesn't really necessarily belong to that author any more than it does to you? These are judgment calls that are necessary to make. Obviously, if you're quoting somebody's exact words, different story, even if it's about a factual matter. Personal photographs and other types of photographs and illustrations, that comes up a lot. If you're, people who are biographers often want to use material that belongs to, say, a family. It's never been out in the world. It's never been registered, of course, but it's also never been published. Do not assume that things are simply no longer protected under copyright simply because they're private property, or because they're old and you're assuming they're in the public domain. etc., that may not be the case. They may very well be protected by copyright, and it's better to assume that things are than they are not, and to try to make contact with the parties to obtain permission to use them. Sometimes, depending on what it is, you don't need to go through a lot of rigmarole to get permission, say, to use a photograph in your biography. It might be just enough that you've got the permission. Another thing about this, for anyone who does not know, it will be the author's responsibility almost always. I don't know that there may be circumstances where publishers are more helpful in this regard, but generally, especially if you're working on, say, a nonfiction book or something, the publisher is going to expect you to obtain the rights to use whatever material you're using, and also to show evidence that you have obtained those rights. And that gets into another kind of practical matter that I certainly have encountered, which is, just because you might even have a legal basis for using something, let's say you think it's probably a fair use, or it may well be in the public domain, etc. If it's a party, let's say it's a museum that owns a photograph that wants to charge you $100 for a copy and permission to use that photo, that $100 isn't worth even opening the question on a legal matter. It's easier to pay that licensing fee. Moreover, the publisher themselves may want to play it safe. I've seen this come up with things like lyrics. Can I quote lyrics in books? And in principle, yeah, a lot of lyrics quotes would arguably be fair use. However, a publisher might say, regardless, we still want to get permission for this. And so you should be prepared for that as just a practical matter that often comes up. So with that, before we turn it finally over to Q&A, I want to point out that anybody who is a member of the Authors Guild can try RightsClick for free for 3 months. If you think it might be the kind of tool that would be useful for you, you can go into the member section and follow the instructions there. Try it for free for 3 months, and then also it would roll over then to a $5.95 a month subscription, which is about $6 off our list price that we offer to special members of groups like this. And in case I didn't mention it, our in-app registration fee is $15 per application, $15 per application, rather than the $30 that we charge via the internet, or via the website, I should say. So with that said, I will now turn it over to just Q&A, and thank you all for listening to the presentation.
All right, thank you so much. That was very informative. We do have a ton of questions coming in. Let's see here. So a few of the things I'm going to ask might have been answered, but for clarity and for those who may have joined late. So if someone's concerned about sharing their work with a workshop, critique group, submitting their work to agents and publishers, they're wondering if they can and should register that early in the process. So it sounds like they can register at any time if they want to, and then it's just a matter of registering a derivative if substantial revisions are made.
That's exactly right. Registering early protects you against everyone. What if you submit it to a contest, for example, and someone leaks it, or someone unscrupulous just copies it and represents it as their own? If you've registered, you have proof that it's yours. You have proof that you're the author. You have proof that you're the author as of a certain date. You are in a strong position. Now, if you make substantial revisions, the way it works is what you registered the first time, that's good forever, for as long as the copyright in the work lasts. Any new authorship, if that's so much new work, new expression that you want to protect that in addition to what was protected in the first registration, then you should file a second registration for that, as Johnny said, that derivative. But if it's only minor tweaks, and really if they take the derivative version, they're taking the original version too, then maybe that's good enough, and that first registration protects you sufficiently. that's a judgment call. You're muted, Johnny.
Thanks. So a lot of people asked, how are you register a copyright? That's something an author can do. But I'm wondering, copyright.gov has FAQs and things like that. But can you tell us a little about what goes into it? Like how much metadata and other details does a creator need to have prepared besides the work itself?
Yeah, so you don't actually need a lot of information. You need to know what kind of work it is. Yeah, you need to know your own name, your your address, things like that. It's not a ton of complicated information in that regard. There are a couple of things that come up that are a little more complicated. For example, limit of claim is a part of a registration application, which refers to material you did not create. So again, a really good example would be a nonfiction book that has photographs in it that you did not take. So you would claim the text and you would disclaim the photographs that are not yours when you submit, if you're submitting the entire work. Likewise, if you had large passages of quotes, you might disclaim the text that you did not create. It's otherwise fairly straightforward. We make it a lot simpler within RightsClick, but even within the archaic system they call ECO at the Copyright Office, it's still the information you need to have prepared is not greatly detailed. You don't need to come in with a ton of information. Steve, would you agree?
Yeah, I mean, it part of it depends on what you're trying to do. If all you want to do is register a single work and you're willing to, deal with the Copyright Office website, you can figure it out. I mean, there are hitches. Sometimes doesn't work well on certain browsers, and on the weekends, it's often down for maintenance. The greater, but you can work your way through it if you give it some time. The more substantial difficulties come in terms of trying to be efficient. For example, you'd have to do some digging on the Copyright Office website to figure out that if you want to register a group of works, you can register up to 10 literary works, but only if they're all unpublished and all by the same author or group of authors. RightsClick was built to simplify all this. You upload your works, you click register, and if there's something about the group that you selected that doesn't fit the Copyright Office rules, the RightsClick system will tell you, oops, we got to fix this. So it saves a lot of time in that respect. And there were a number of questions in the chat about different types of work. So for example, someone asked about photographs. You can absolutely register photographs. There are different rules for group registration of photographs. You can register up to 750 in a single application. And it can be 750 all published or up to 750 all unpublished, but you can't mix published and unpublished in groups of photographs. Again, is this all on the Copyright Office website? Yep. And if you dig around, can you find it? Yep. With RightsClick, you don't have to.
Quite a few people have asked, should I register at this point in time and under different circumstances? Is that the deciding factor is basically whether you want those protections that we outlined at the beginning, the ability to file a lawsuit and things like that.
So you're asking, should you register the manuscript prior to publication or distribution?
Right.
Yeah. So it's a judgment call. Steve mentioned things like contests and whatnot. Speaking in my experience, I consider things like contests and anything I'm sending out into the world of that nature to be basically the hunting ground. So I would want all the protection I could get before I even considered sending to those kind of organizations. Whether I sent something to my literary agent, that's a judgment call. Whether you feel like, you want that kind of protection before you send it to a colleague of that nature, that's certainly you're fully protected the moment you do. Whether that's practical for you prior to that individual is about your relationship with that individual, how much you trust them, how likely you think something is to get leaked. Unfortunately, the other reality is that we live in a world of leaks. You know, we live in a world of stuff getting out there unintentionally all the time, and so there's that to be considered as well. But that's just a question of everybody's circumstance is a little bit different, in my opinion.
Mhm. Is there a hard time limit on registering? People asked about registering works years ago. Is there anything preventing them from doing so?
No, as long as the copyright hasn't run out, which is the life of the author plus 70 years, so that's pretty long. As long as you can register anytime within the life of the copyright. We recommend registering earlier, again, because that way you're getting those additional remedies against the most possible number of infringers. You know, if you register before an infringement starts, then that's beneficial. And as I've answered a couple of questions in the Q&A, if you register before works are published, then you can use the group registration for literary works. You can combine 10, up to 10, in a single registration and only pay the fee one time, as opposed to if you wait till those same 10 works have already been published, then you have to file each one individually. And you have to go through the process 10 times, and you have to pay the application fee 10 times.
Does that apply to like poems and short stories? Maybe they've been published and then you're collecting
Yeah.
them in a book.
So I'm glad you asked that, because you know, it's a consideration, right? If I were writing a bunch of short stories that I might use in different ways, then I would take advantage of the group of 10, and group register those. If I knew I'm combining a whole bunch of work into one book that I'm gonna pitch as one book, even with my photographs and my poetry and short stories and essays all in one book, I'd wait till I'm done with the whole thing, because I can take advantage of registering that entire book and everything in it under one registration. So that has to do with how are you using your work, how are you planning to use it and release it into the world, and then you take advantage of whichever of the two is the most economical and efficient, if that makes sense. And if it didn't, please let me know. So,
I think so. So you mentioned disclaiming parts of a work that are not copyrightable. Some people asked about multimedia works. Someone writes books of knitting patterns. I believe cooking recipes cannot be copyrighted, but the instructions can. Is there does the Copyright Office make it clear what has to be disclaimed in that regard?
No. In a word, no. When you file a registration application, you are asserting that you are either the author and or the claimant, meaning the copyright owner, of at least some creative elements in that work. So for example, if you've written a book and you have used illustrations by a different author in your book, and assume you got permission for them, it's all above board, you're all good, you're still not the author of those illustrations. And so what you'd want to do in a situation like that is click limit of claim and disclaim the illustrations and assert copyright in the text. And that's a way of telling the Copyright Office, this is the part that I made.
Okay. What about translated works? If the specific question was, if the original is in the public domain, can you copyright a new translation of it?
Yes.
But if you have any other advice for translations, that would probably be helpful.
Sure. Translations are considered derivative works. So if the original underlying work is in the public domain, that means, for those of you not familiar with that term, that means copyright has expired. Obviously, you don't need permission to do anything with a work for which copyright has expired, so you don't need to worry about getting permission or paying licensing fees. The translation that you've created is considered new creative expression. And so you can register that as a translation. And you simply indicate that to the Copyright Office in the application. There are places, for example, there's a box for notes to the Copyright Office to provide a little explanation if you think it's necessary above and beyond just the sort of click buttons that they have. And you can just put in there, this is a translation of a public domain work.
Can you speak to Creative Commons licensing? Someone asked how much weight that carries.
So for those of you not familiar with the term, Creative Commons license is it's a copyright license, and it's saying that the author of the work is putting it out, allowing people to make many uses of it. It's a very permissive type of license. So you could write a sequel, let's say, if there's a Creative Commons license that allows you to make derivatives, you could go ahead and write a sequel, and you'd have permission by virtue of that license. But the Creative Commons license is usually written in a way that says, but you can only do that if you make your work available under the same terms. So if your idea is that you want to write a sequel or derivative and then use that to protect and you want to protect your copyright in that and sell copies of it, you may need to be a little more careful, because the Creative Commons license would not permit that. And if you try to do that, you're no longer in compliance with the license and your use could be infringing.
Yeah, I would want to emphasize, whatever the terms of the Creative Commons license state, take them seriously, because what underlies a Creative Commons, a lot of people think of it as the opposite of copyright. No, it's still protected under copyright law. So people who fail to live up to the terms of that license have been sued, and you could be. So read those and honor them if you're going to use something under Creative Commons. Some, and admittedly, some Creative Commons licenses will say use freely, give me attribution, and that's it, and they have no further restriction. But definitely pay attention to what they say.
Someone asked, is there a ballpark word count for fair use? Fair use, I know, gets murky pretty quickly. So I should say, we've done some talks on fair use with Mary Rasenberger, CEO of the Authors Guild. We'll do a Ask the Authors Guild chat with members fairly soon. And that might be a better place to get into the weeds on the fair use stuff. But there aren't really numbers about how many lines of a poem or anything like that, right? They're just rules of thumb.
They're not even rules of thumb. The fair use, the great thing about fair use is it's very flexible. It's a doctrine that's been in US copyright law for well over 100 years, and we can still apply it in the age of the internet and digital technology and even AI. But the price of that flexibility is it rarely gives you a clear yes or no answer, or bright guidelines like, okay, you can use 15 seconds of a song but not 16. No, it's not that clear. You can use 15 words but not 16 words. No, it's not that clear. It depends on lots of particulars about the facts. So, for example, if I were to say to you, oh, it's okay to use less than 15 words, and the 15 words you chose to use were, it was the best of times, it was the worst of times. Oops, that may not be such a simple analysis. Well, that's probably
pick something from the public domain.
Yeah, that's a bad example in the sense that copyright has expired on that work. But the idea is, one of the considerations in fair use is whether what was taken is the heart of the work, not just how many words or pages did you take.
Yeah. And the only thing I would add to that is, whenever a question comes up of amount, keep in mind that amount is only one of 4 questions that are asked by the court as to whether something is fair use. So it's not just about how much you used, but as Steve said, whether you use the heart of the work, but also why you used it, what is the context, what is the potential threat to the original, to the value of the underlying work. Those are all questions that come into play. So you can't just look at them out in a vacuum.
One more on a copyright basic. Someone asked if your work was copyrighted by the publisher, let's say in an anthology, and the rights revert to you, can you still copyright that work? So that's so I think they mean the publisher copyrighted the anthology and the publisher owns that copyright.
Well, to be clear, they've submitted the registration. So they registered the work. They registered an anthology, which included your work. And then I'm glad this came up because there were some questions I saw about duration of contracts and that sort of thing. There is a provision in the copyright law that allows you to reclaim your rights that you've licensed away after 35 years. Now, I know that's a long time, but the idea is, a budding young author sold the rights to their work when they were 22 years old, and they got almost nothing for it. And then they turned into a Pulitzer Prize winning, author who sold, millions and millions of copies. At some point, they can reclaim their rights. It's called termination, and that process allowed under the Copyright Act. So they could actually have licensed it to a publisher. The publisher submitted the registration, and then after 35 years, the author could reclaim their rights through that termination process. Even if the initial contract said we're conveying rights for the full duration of the copyright, you can still terminate it after 35 years under the law. Now, a registration for a work lasts for the entire duration of copyright in that work. And everything that's protectable, that's within a registered work, so like an anthology, that would protect everything in the anthology. And the Copyright Office, in fact, will not allow re-registration of the same work. When the publisher registered it, yes, they would have indicated themselves as the copyright owner, which the Copyright Office calls the claimant, but they would have had to indicate the individual or group of individuals who actually wrote it as the author. And so you would have that, and then you would just, if you were in court, you'd have to connect the dots. Say, here's the registration that says I'm the author. Here's my termination document that shows I got the rights back. I'm the author and the copyright owner. Let's go.
Okay, that makes sense. Thank you. Now, forgive me if I heard it, but I've been pretty deep in reading the hundreds of questions coming in. But about artificial intelligence, what's the status of what's copyrighted? Let's say a work that an author has written with the assistance of AI. How does that work if the AI part isn't?
So this is evolving law. We know pretty clearly that anything that's generated purely by an generative AI system is not copyrightable. There has to be some degree of human authorship. The Copyright Office has said that, and court in Washington, D.C. has said that, and there's not really a lot of argument about that. The shades of gray that come in is how much human authorship does there need to be? So you start with an AI, it spits something out, and then you start rearranging it, and you change some words, and you add another paragraph. And where along that spectrum does it cross over into copyrightable? That's a bit of a gray area. Generally speaking, the law only requires what the Supreme Court has said is a modicum of creative expression. How many words in a modicum? I couldn't tell you, no one can. It means a little
15.
bit.
There's 15 words in a modicum.
15, okay. So you stand by that, not me. A little bit of human creative expression will do the job. Now, since you've asked this, I need to mention the Copyright Office has issued a guidance saying that if you want to submit for registration a work that was partially generated by AI and partially human authorship, you need to tell that to the Copyright Office, disclaim the part of it in the limit of claim section that was generated by the AI, and in one of the boxes, that are provided, for example, the note to the Copyright Office box, you then need to explain what was the human authorship, because they need to know that, in their view, in order to know whether or not there's sufficient human creative authorship to justify registration.
Yeah, and in describing that, consider that the purpose of registration is to provide a basis for potentially going to court if you had to. So imagine yourself explaining it in a court where they're going to, deduce what is the truth. I wrote this, I didn't write that, and build, obviously it may be more complex than that, but that's essentially what the Copyright Office is asking you to put in the form. Is what did you create? What did you not create? It's as Steve said, it's a form of the limit of claim in terms of the way they're approaching it.
Right.
Great. Well, I think we can begin to wind it down here. We've covered a lot, but of course, members of the Authors Guild can make use of our legal services. Also, our members forum I find to be pretty helpful, because you might be in a very tricky, unique situation, but with thousands of other authors, you might crowdsource a good answer from them as well. But about RightsClick, so, Authors Guild members have some discounts and partnerships with other organizations. You said there's a free trial membership. You help photographers, and also stage plays and screenplays and such?
Yep. It's the goal is to create tools that any kind of creator can use, and that's part of the trick. As Steve mentioned, photography has its own set of rules and its own set of considerations, both in terms of registration and administratively. But our goal is to try to help every type of creator we possibly can.
And some people have said,
if you have specific questions, by the way. Sorry.
Some people have wondered, what if I've only written one book? It doesn't sound like I need RightsClick. I can just file the copyright with, and maybe that's the case, but for those who need more,
exactly,
that makes sense.
If they want to use the Copyright Office system and it's just a single registration, yeah, it's possible to figure that out. If they don't want to spend the time, you can just go to rightsclick.com, and we have a single work application right there on the website. You don't need a subscription. You can do it in about 90 seconds. It's all very straightforward and one and done.
Great. Oh, I'm sorry. There's one little question I wanted to ask. What about pen names, pseudonyms? Is it difficult to keep your identity private while filing a copyright registration?
You can do that. You have to indicate that you want to keep you can use a pseudonym. And since you raised it, there's a distinction. If you fill out either whether through RightsClick or in the Copyright Office, and you say, this is my pseudonym, and then you put in your pseudonym or that the name you've entered is Dr. Seuss, for example, that's how it's going to appear on the registration. It's not going to be assigned to your natural name, or it's going to be assigned to the pseudonym, and it will be treated as a pseudonymous work, which has different terms of protection. So make sure you look at that as a consideration. It's not wildly different, but it's different. Alternatively, if you just want to register it in your name, but also indicate that a pseudonym appears on it, that's a slightly different instruction that you would see both if you were using RightsClick or in the office, where, although it's harder to find in the office, where you would say, basically, I'm registering it in my name, David Newhoff. However, my pseudonym appears on a copy of this work, and that goes into the instruction in the Copyright Office. And that way, that term of copyright protection, the life of the author plus 70, still applies, which is different if it's a pseudonymous work. So that's a consideration for each creator.
Great. Thank you. Thank you. A lot of people sending their thanks in the Q&A box. Thanks to everyone for being here. You asked a lot of great questions, and I hope we've all learned something today. Thank you, David and Stephen from RightsClick, for joining us for this.
Thank you all very much.
Thanks very much.